In the heart of London's legal quarter, a bright-eyed law student named Eliza returned from court, her mind buzzing with questions. She sat across from her mentor, Mr. Hartley, a seasoned solicitor whose love for legal history matched his flair for storytelling. She asked, "How do judges decide whether something said during negotiations is just a casual remark or an actual promise?" Mr. Hartley leaned back, eyes twinkling. "That's not a question you answer with a definition," he said. "You answer it with 3 stories." He began with the tale of a man named Routledge, who was tempted by a motorbike that a seller described as a 1942 model. The seller, McKay, had casually mentioned the year based on what he'd seen in a logbook, though he wasn't entirely sure. A full week passed before Routledge returned to buy the bike. When they finally signed the contract, it made no mention of the motorbike's age. Later, Routledge discovered the bike was actually a 1930 model. Outraged, he sued, claiming breach of contract, but the court disagreed. Since the statement about the bike's age was made days before the formal contract and wasn't included in the final written terms, it was seen as a mere representation, not a binding promise. The delay, the lack of written inclusion, and the buyer's opportunity to investigate all signaled that this was not part of the deal. Routledge lost. Without pause, Mr. Hartley continued with another story. This time it was about White, a hop merchant, who asked a crucial question before buying hops from Bannerman. "Have these been treated with sulfur?" The answer, "No," was pivotal. White made it clear that he wouldn't proceed with the deal if sulfur had been used. Reassured, he went ahead and bought the hops. Later, he discovered that sulfur had in fact been used on part of the crop. When he sued, the court ruled in his favor, because he had clearly stated that the presence of sulfur was a deal-breaker, and Bannerman's answer was the reassurance he relied upon. The statement was held to be a term of the contract. Unlike in Routledge's case, the timing and the expressed importance of the statement transformed it into a legally binding promise. Bannerman's false assurance cost him dearly. Then came the story of Schawel, a man searching for a horse suitable for breeding. He met Reade, who confidently claimed the horse was perfectly sound. When Schawel attempted to inspect the animal himself, Reade waved him off, repeating his earlier assurance. Trusting this, Schawel bought the horse. Only later did he find out the animal had a hidden defect that made it unfit for stud purposes. The court held that Reade's statement was more than a representation. It was a contractual warranty. He had not only made a specific claim about the horse's quality, but had also actively discouraged the buyer from conducting his own checks. That assurance, the court reasoned, had to be treated as a binding promise. Schawel was entitled to damages. Eliza sat back, piecing the stories together. So in Routledge's case, the statement came too early and wasn't part of the final contract, so no liability. But in White's case, the buyer made the importance of the statement clear. And in Schawel's, the seller discouraged inspection and gave a firm assurance, so it became a promise. Exactly, Mr. Hartley said with a nod. In the law of contract, it's not just what you say, it's when you say it, how much the other person relies on it, and whether the words are meant to be binding. That's how you draw the line between a representation that comforts and a promise that binds. A contract, he added, is as much about timing and trust as it is about words on paper. As Eliza left that day, the law felt less like a web of abstract rules and more like a human story, full of caution, confidence, and the quiet power of a single sentence spoken at just the right time.